Assalamualaikum warahmatullahi wabarakatuh. This is part 3 for Zoom recorded lecture for the topic consideration. So previously we have discussed about types of consideration. Okay, we discussed thoroughly about past consideration. So now we want to focus on another subtopic, which is adequacy of consideration. So what is meant by adequacy? So another, if we were to Google or look in the dictionary, okay, adequacy or adequate will be synonymous with sufficient. Okay, but in the eyes of law, especially in contract law perspective, adequacy and sufficiency, they have two different meanings, two different interpretation. Okay, legally speaking. All right. So what's the rule here? The rule is that consideration must be sufficient, but need not be adequate. Meaning that here, if it is sufficient, then it is valid. And then no need to prove that it is adequate. What the meaning here? Okay, want to know what's the legal interpretation, legal meaning here. And then another, the explanation to the rule is that, okay, where a party, a contracting party, okay, denies that his consent was freely given, then inadequacy of consideration may be taken into account to determine whether his consent was freely given or not. Mean that here, the requirement of adequacy here, all right, it relates, okay, it is intertwined with the requirement of consent. Actually, you are going to cover a lot. The requirement of consent here will be covered under contract law part 2, okay, law 1211 later. But we are going to have a look at section 14 Contracts Act, which relates to free consent, and also followed by explanation 2, section 26 Contracts Act, and also illustration F. And later we are going to have a quick look on section 27A, Specific Relief Act 1950, all in relation to rule pertaining to adequacy of consideration. Okay, let's have a look at section 14 first. Okay, show the section 14 first. Okay, section 14, okay, the topic is free consent. Okay, the subtopic, the subtitle, the title here. And then here it talk about consent is said to be free when it is not caused by coercion and influence, fraud, mistake. And then explanation here, the provision here, consent is said to be so caused, okay, when it will not have been given, but for the existence of such coercion and the influence, fraud, misrepresentation, or mistake. So it talk about elements of free consent, which is a requirement under Contracts Act for a contract law to be considered as valid. We go to section 26, explanation part. I need to scroll down. Okay, this is 26. Okay, 25, 26 here. Okay, agreement without consideration void unless, and then we focus on explanation 2. Okay, we have 2, but the first one, okay, explanation 2, it says here, it is stated here, an agreement to which the consent of the promisor is freely given is not void, okay, merely because consideration is inadequate. But the inadequacy of the consideration may be taken into account by the court in determining the question, okay, the issue, whether the consent of the promisor was freely given. If there is any issue with the element of free consent, then the court will look at the adequacy. Is it adequate or is it inadequate? Okay, whenever there's any problem with the elements of free consent. If the consent is free, then there's no need to investigate further. Okay, it's okay whether adequate or inadequate. But the moment the consent is not freely given, then the court will look further, see whether is it adequate or is it inadequate. Another relevant part is illustration F here. It relates, impliedly it explains about the concept of adequacy. A agrees to sell a horse, okay, worth 1,000 ringgit Malaysia for 10 ringgit. Yeah, I'm selling my horse. My horse is worth 1,000, but I'm selling it to you only for 10 ringgit. So here, A's consent, the horse owner, okay, to the agreement was freely given. So I'm offering you freely. There's no one forcing me to do so. Okay, so is it a valid contract? And first of all, yes, the agreement is a contract, notwithstanding the inadequacy of the consideration. Obviously, 10 ringgit is inadequate for the, if you were to compare with the true market value of the house, which is 1,000. But because the consent was free, freely given, voluntarily done. Okay, freely given. There's no, no problem. Okay, with the inadequacy of the consideration. Okay, we go to specific relief act. Section, what section just now? Section 27A. Okay, this is SRA 27A. Okay, specific performance of a contract cannot be enforced against a party thereto in any of the following cases. Okay, A, if the consideration to be received by him is so grossly inadequate, okay, with reference to the state of things existing at the date of the contract, okay, as to be either by itself or coupled with other circumstances, okay, evidence of, here, there's no specific performance, okay, if the consideration was inadequate, okay, again, but then the court will look at whether the consent was freely given or not. So the two requirements are related or intertwined. Actually, we go back to our slides. Okay, we have just now we look at section 14, okay, and section 26, okay, on the part of explanation 2 as well as last section F, and then also section 27A, specific relief act. Let's go to the case law. This is judicial interpretation of the concept of sufficiency and adequacy. The case name is Tan Chiu Tu and T Kim Kwei, 1997. Here we focus on the judgment, the relevant part of the judgment here, actual quotation from the decision of the court. So it is stated here, it must be remembered that sufficiency of consideration is different in law from the adequacy of consideration. Though any dictionary may show both words to bear the same meaning. So if it is not legal context, then it has similar meaning. But in the context of contract law, it has different meaning altogether, sufficiency and adequacy. Okay, in law, the courts will often inquire into sufficiency, okay, but not the adequacy of consideration. Okay, so what's the meaning here? Sufficiency in law is synonymous with validity in regard to consideration. Meaning that here, if the consideration is sufficient, then it is valid. Doesn't matter whether it is adequate or inadequate. Okay, so what's the meaning of sufficiency again? So providing consideration has some value, then the courts will not investigate its adequacy. So some value here, it means this is sufficiency. So even though it might not be adequate. So where consideration is recognized by the law as having some value, it is described as real or sufficient considerations. And the court will not investigate contracts to see if the parties have got equal value. Doesn't matter. Is it equal to value? Okay. Is it adequate? Meaning here, in other words. So, and then, consideration must be certain, must have certain value. Certain value is some value, it means sufficient. But of course, it's not, maybe it's not adequate, but it's okay. So long it is sufficiency. Okay. And then in the eyes of law, a nominal consideration is good consideration, even though just a small amount, okay? Although the value may be slight, okay, or negligible, small amount. So value in the eyes of law is subjective matter because a thing has value if the parties attribute value to it. So it might differ from one party to another. We have classic case, common law, 19th century case, Thomas and Thomas, 1842. So in this case, it involved a promise to pay £1 only per annum a year, okay, for the rent. So was irrelevant, okay, to the facts of sufficient to pay for commercial rent. Mean that here, certain value is paid. Okay, so the court did not consider the issue of adequacy. So obviously, £1 is inadequate. But is it sufficient? Okay, yes, it was sufficient because there's certain amount of money. It's not for free. Okay, there's payment, some value which was being paid, even though it doesn't reflect the commercial rent. Okay, the rate doesn't reflect the commercial rent. And we have another landmark case here, common law. The case is Chappell and Company Limited and Nestle Company Limited, reported in year 1959. Another nickname for the case, okay? Another way of, it's like when you have a color and small ball company, that was small ball case, right? Here, chocolate wrapper case. Here, that's the nickname, okay, of the case. It's about chocolate wrapper anyway. What happened was that Nestle, the company, okay, they were running a special offer, okay, whereby members of the public could obtain a music record by how to do it, okay, how to get the free music record here. Sending off 3 wrappers, okay, from Nestle's chocolate bars and some money so that they can get the music record. And then the issue about the copyright, okay, the copyright to the records was owned by Chappell. And Chappell said, well, by doing so, actually, there was violation of copyright, okay, breaches of their copyright. They are the one who own the copyright. And then when the case was heard in the court, all right, the issue which is relevant for our discussion here is that whether, okay, the 3 wrappers here were part of the consideration. Does it have any value or not? The empty wrappers here. So the court said yes, okay, in that particular context, they were, okay, even though, okay, they were then thrown away when received. I mean, in reality, the empty chocolate wrapper, it doesn't have any value. But for the purpose of promotion here, it has the value from perspective of Nestle. So the whole object of Nestle selling the record, okay, was to increase the sale of their chocolate. Okay, that's the purpose. Okay, it all relates to commercial interest here. So acquiring and delivering of the wrappers to Nestle, actually, it has economic value, okay, and was certainly part of the consideration. And the court also, I mean, relates to freedom of contract here, because parties should be allowed to determine for themselves what is a fair bargain. So as far as Nestle and the public at large, their consumers, customers are concerned, so it's fair between them. Okay, and then whatever activities between them, it relates to commercial, okay, commercial in nature, commercial interest. So it has some economic value. Okay. So in other words here, okay, consideration is sufficient, is valid, okay, where it amounts to something that is capable of expression in economic terms. Okay, this is we learned from the chocolate wrapper case just now. Okay, and then if it is merely sentimental motives, okay, to make a promise, so it does not amount to sufficient consideration. Okay? Sentimental, so it's not possible to be translated into commercial or economic, okay, economic value element here. This is what happened in this case, White and Blewett. Okay, 1853. So who was Blewett here? Blewett, he was sued by his father's executors, okay, because Blewett has some outstanding debt to his father. And then Blewett said, the son, basically, okay, he claimed that his father had promised, okay, to discharge him from the debt. Okay, so what's he, I mean, in consideration of what? In return for him to stop complaining about property distribution. All right, the court held that the act of stopping complaining, okay, cessation of complaints here, cease, okay, cessation of complaints here, actually there's no economic value. Okay, so in other words, there's no exchange of real consideration, valuable consideration here. So Lewett's father had received no real consideration for the promise. All right, so with that here, it's not sufficient in the eyes of law. Okay. Okay, let's recap. So this is all the summary that we have discussed earlier about sufficiency of consideration. Okay, so long as the consideration has some economic value, which is capable of being translated into money, okay, monetary value, then yes, in the eyes of law, it is sufficient, it is valid. So, having said so, okay, it is sufficient consideration to pay whatever amount, 1,000 for example, for a new car worth 80,000, like when we read illustration F just now, okay, payment of 10 ringgit for a horse value, the real value is 1,000 for example, it's possible. And then such consideration, okay, is valid because why? It is sufficient. Valid, why? Because it's sufficient, even though it is not adequate, okay, because it's not, it doesn't reflect the true market value. And the court would not interfere just because it appears that a person had made a bad bargain. Doesn't matter. Okay, you decide, okay, what bargain whatsoever. Okay, the court won't interfere further. And then because why? The reason is that, okay, when we talk about issue of adequacy here, okay, the court actually give more consideration. I mean, the court approaches that, okay, the court actually make it a freedom. I mean, the court give more priority, okay, to freedom of contract. So long the parties give consent, okay, they are free to make their own bargain, even though if maybe it's a bad bargain, okay, it's okay so long it is sufficient, so long it is valid, so long certain money being paid, it's not free of charge whatsoever. All right, so that's basically the approach by the court. Okay, and this is the last one. So mere inadequacy of consideration, okay, most of the time is not a sufficient ground for setting aside a contract, unless you can prove the consent was not freely given. Okay, so long everything was freely done, okay, freely given, free consent. So again, it's a matter of freedom of contract. Okay, the parties are free to set whatever value between them, okay, whatever amount of money to be paid whatsoever. We have another case actually by federal court. You can have a look at the case later. Pang Swee Kim and Beh Ai Hock reported in 1964. So it relates to the rule. I mean, illustrate the application of the rule about adequacy of inadequacy or adequacy of consideration. Okay, that's all for now. We are going to continue later. Next topic will be forbearance to sue. Okay, I'll stop share for a while.